Hello everyone, welcome back to VIVA channel. This is Tony. Currently, I believe that there are some companies are facing with the difficulties during operation in Vietnam due to the economic crisis. And today, I would like to share with you about how to close a company. Shutdown and dissolution are legal procedures to terminate the existence of an enterprise under resolution or decision of the owner, the board of partners, the board of members, and the owners, or the GMS for joint stock companies. Shutdown and dissolution of an enterprise are more and more complicated than procedure of registration for establishment, management, reorganization, and shall be followed by the conditions and procedures as below. So here are the cases and conditions for shutting down and dissolution of an enterprise. An enterprise shall be shut down and dissolved in the following cases. The first one, the operating period specified in the company's charter expires without an extension decision. Second one, the enterprise is dissolved under resolution or decision of the owner, the board of partners, the board of members, and the owners, or the GMS applied for joint stock company. The third one, the enterprise fails to maintain the number of members prescribed in the law in the 6 consecutive months without converting into another type of business. And the last one, the certificate of enterprise registration is revoked unless otherwise prescribed in the law of tax administration. And here are the conditions for enterprise to shut down and dissolution. Firstly, an enterprise may only be dissolved after all of its debts and liabilities are fully paid and it is not involved in any dispute at the court or arbitration. Secondly, relevant executives and the enterprise indicates the certificate of enterprise registration that is revoked are jointly responsible for the enterprise debts. Now we move on to the procedure how to close a company. The procedure step by step of closing a company should be carried out as follows. Number 1, a resolution or decision on the dissolution is issued. Such a resolution or decision should contain the following information: the enterprise name and headquarters address, reasons for dissolutions, time limits, and procedure for finalization of contracts and payment of the enterprise debts, plan for settlement of application under employment contracts, full name and signature of the owner of the sole proprietorship, the company's owner, the president of the board members, the president of the board of directors. Number 2, the owner of the sole proprietorship, the board of members of the owner, the board of directors directly organize the liquidations of the enterprise assets, unless the company's charter requires establishment of a separate liquidation organizations. Number 3, within 7 working days from the ratification date, the resolution or decision on dissolution and the minutes of the meeting shall be sent to the Business Registration Authority, Tax Authority, and the enterprise employees. The resolution or decision shall be posted on the National Enterprise Registration Portal, displayed as the enterprise headquarters, branches, and representative offices. In case the enterprise still has the unpaid debts, the resolution or decision and the debt payment plan shall be sent to the creditors and the persons with related rights, obligations, and interests. The debt payment plan shall contain the creditor's names, debts, payment time, location, and method and time limit for settling the creditor's complaints. Number 4, the Business Registration Authority shall post a notification that an enterprise is undergoing dissolution. The dissolution resolution or decision in debt payment plan, if any, on the National Enterprise Registration Portal right after the resolution or decision is received. Number 5, an enterprise debt shall be paid in the following order of priority: unpaid salary, severance pay, social insurance, health insurance, unemployment insurance premiums, and other benefits of employee under the collective bargaining agreement and concluded employment contracts, tax debts, other debts. The enterprise legal representative shall submit the application for dissolution to the Business Registration Authority within 5 working days from the day on which the enterprise debts are fully paid. And the last one, after 180 days from the receipt of dissolution, resolution, or decision without further comments from the enterprise or written objections from relevant parties, within 5 working days from the receipt of application for dissolution, the Business Registration Authority shall update the enterprise status on the National Enterprise Registration Database. After the procedure of shutting down the company, now I would like to share the application for closing a company in Vietnam. The application will consist of the following documents. The first one, the notifications of the enterprise dissolution. Number 2, the report on liquidations of the enterprise assets, list of creditors, head debts, including tax debts, social insurance, health insurance, unemployment insurance of employees after the dissolution decision is issued. Number 3, members of the board of directors, the owners, the director, general director, general partners, and legal representatives shall be responsible for the accuracy and truthfulness of the application. Number 4, in case the application contains inaccurate or false information, the owners or management persons shall jointly provide the outstanding employees' benefits, taxes, and other debts, and bear personal responsibility for the consequences that occur within 5 years from the day on which application is submitted to the Business Registration Authority. Besides, kindly noted that there are some actions that prohibited from the issuance. Date of the shutting down and dissolution decision. From the issuance date of the shutdown and dissolution decision, the enterprise and its executive are prohibited from the following actions: concealing, disguising assets, denying or reducing the creditor's claim to the debt, convert insecure debts into debts secured in the enterprise assets, concluding new contracts except for dissolving the enterprise, pledging, donating, leasing out assets, terminating affected contract, raising capital in any shape or form. For those companies has the branches, representative office, and business locations, all of them should be shut down as well. Shutdown of branches, representative offices, business locations of an enterprise shall be decided by the enterprise or under decision to revoke the certificate of branch representative office registration issued by a competent authority. The enterprise legal representative and the head of branch representative office that is shut down shall be jointly responsible for the accuracy and the truthfulness of the application for shut down the branch representative office or business location. The enterprise whose branch is shut down shall execute the contract and pay the debts, including tax debts, of the branch, and continue employing or fully provide lawful benefits to the branch employees as prescribed by law. And kindly noted that one of the most challenging procedures in shutdown and dissolution of an enterprise in Vietnam is tax inspection, tax settlement, and tax completion certificate by all for the finance staff at the licensing department. The enterprise keeps accounting records in accordance with accounting laws, tax reports, lawful invoice for investment, revenues, expense during its operation, and is ready to prove for any tax application and fully pay tax arrears on tax inspection decisions. I believe that the content I shared today will be helpful for those companies who has the plan of closing a company in Vietnam. Should you need any further assistance, please let me know.